PRI is back in session. The Honorable Ronda presiding. You may be seated.
All right, defense ready to resume?
We are, Your Honor, but I believe that there is a matter with the state that we may need to put sidebar.
Okay.
With the court clerk, please.
Yes, sir. I have had the opportunity to review our discussion and your ruling with Mr. Dunn and discuss with him the ramifications of that ruling. And he's in agreement, Your Honor, at this time, the defense would rest.
All right. Then, if you'd like to make your motion. And then what we'll do is, when the jury comes back in, you just announce rest again.
Yes, sir.
Mr. Carlisle.
Your Honor, at this time, the defense would once again renew our motion for judgment of acquittal. We would rely on our previous argument as to premeditation, and we would also argue that the defense has now established a prima facie case of self-defense. The burden is once again with the state to prove beyond a reasonable doubt that Mr. Dunn did not act in self-defense. We don't believe the facts of the case warrant that, and so we would move for a judgment of acquittal, again, as to premeditation based on our previous arguments, and as to self-defense and the state not proving beyond a reasonable doubt that he did not act in self-defense.
All right. Ms. Corey.
Judge, we believe that we still have the right to go to the jury with this case, that Mr. Dunn's statements have to be considered in light of his interest in the case. He's now become a witness in this case, and the jury is entitled to assign whatever weight they deem appropriate to his testimony. So we believe that we are still able to take this case to the jury and ask that you deny their second motion for judgment of acquittal.
All right. Based on the reasons that I gave at the end of the state's case, denying the motion for judgment of acquittal at that time, and again, although Mr. Dunn has testified, it's fact-based and it's something for the jury to consider and weigh the testimony that they have as to what they believe actually took place. So therefore, the state has, to this point, in the light most favorable to them, presented a prima facie case that should be presented to the jury, so the motion for judgment acquittal is denied. And I guess now we can bring the jury on in. All right? Bring the jury in.
Jury men in the courtroom.
All right, ladies and gentlemen, welcome back. Thank you for your patience again. Ms. Hanania.
Your Honor, at this time, the defense rests.
All right, ladies and gentlemen, the defense has now rested their case. The state. Ms. Wolfson?
Yes, Your Honor. State calls Ronda Rower.
Ronda Rower, please. Ms. Rauer, if you'll come all the way to the front again for me, please, ma'am. And if you'll raise your right hand, the clerk will administer the oath.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, ma'am, if you'll come around and have a seat again for me. And again, you adjust that microphone as you need. Be sure and speak loudly into it.
Yes.
Ms. Wolfson.
Good morning, Ms. Rauer.
Good morning.
I'd like to turn your attention back to the morning of November 24th. Do you remember that drive home to Brevard County, back to Satellite Beach?
Yes, I do.
And while on that way home, did the defendant receive a phone call on his cell phone?
Yes, he did.
Was that around 8:30 in the morning?
Yes, I believe so.
Do you know, Ms. Rauer, who called the defendant?
Yes, I do.
And how did you know who was calling?
The phone was on speaker.
So the defendant had put the phone on speaker?
That's correct.
Okay, and who actually was calling the defendant at 8:30 that morning?
Our neighbor, Ken.
And do you know his name?
I do know his name. His first name's Ken. I don't know how to pronounce his last name.
Okay. Does Lcal sound familiar?
Yes.
Now, were you able to hear the entire conversation between the defendant and Ken Lcal that morning?
Yes, I was.
And during that conversation, did the defendant tell Mr. Lcal that you all were headed back home?
Yes.
And did you hear the defendant tell Mr. Lcal that that was because you weren't feeling well?
Yes.
During that conversation, did the defendant ever mention that he had been involved in a shooting in Jacksonville?
No.
Did the defendant ever mention to Mr. Lcal that he needed to speak with him when he got back home to Brevard?
No.
Did the defendant ever mention to Mr. Lcal that he had something important he needed to speak with Mr. Lcal about?
No.
Did the defendant ever mention to Mr. Lcal that he needed to go over to his house?
No.
Now, back on the night of the shooting, that's November 23rd of 2012, when you got back to the Sheraton with the defendant, did you ever tell the defendant not to take his gun out of the glove box?
No.
And earlier that night, when you first came out of the Gate gas station and got into that black Jetta with the defendant, did the defendant ever tell you he saw a gun in that red SUV?
No.
Did he ever tell you he saw a gun in that red SUV while you all were driving to the hotel?
No.
Did the defendant ever tell you that he saw a gun in that red SUV while you were at the hotel?
No.
And the next morning, did the defendant ever tell you on your 2.5-hour drive home that he saw a gun in that red SUV?
No.
Did he ever mention a weapon of any kind to you that he had seen that night?
No.
Have a moment, Your Honor.
Yes, ma'am.
No further questions, Your Honor.
Ms. Hanania.
Ms. Brower, you were on your ride back home to Satellite Beach at the time that this phone conversation takes place between Mr. Dunn and Mr. Lcal, is that correct?
Correct.
Okay. You said the phone was on speaker, is that right?
That's correct.
But you weren't actually a part of the call, correct?
No, I was not.
And you weren't paying that much attention to this call, isn't that right?
That's correct.
And in fact, when y'all got back to Satellite Beach, Mr. Dunn did in fact go over to Mr. Lcal's home, isn't that right?
Yes.
Now, ma'am, you were asked about about the conversations between you and Mr. Dunn on November 23rd and 24th. Ma'am, isn't it true that as soon as you got back into that car, that Mr. Dunn said to you, "I shot at the car"?
That's correct.
Didn't he in fact immediately say to you, "Because they threatened me"? Isn't that correct, ma'am?
I don't recall.
You don't recall having said to, ma'am, didn't you in fact tell Detective Musser, the lead detective in this case, that when you got into that car, that Mr. Dunn said to you that he shot it because they threatened me? Isn't that correct, ma'am?
Yes.
Okay. So you admit to telling Detective Musser that Mr. Dunn said to you when you got into that car, it was because they threatened me. Isn't that correct?
That's correct.
And you told Detective Musser that because that's what Mr. Dunn had told you. Isn't that right, ma'am?
That's correct.
Okay. And didn't he also tell you as soon as that you got into that car that evening that he shot because they started to advance and he reacted?
That's correct.
And that he reacted to protect himself in self-defense. Isn't that right?
Those aren't the words he used.
He reacted because he was afraid for his life. Isn't that those the words you used?
He said I feared for my life.
Okay. Now, and that entire conversation took place between you and Mr. Dunn as soon as you got into the car. Isn't that right?
That's correct.
And you told Detective Musser about that conversation between you and Mr. Dunn. Isn't that right?
Sustained.
And ma'am, isn't it true that you were in a state of shock at that point?
Yes.
Okay. That you didn't know what to do with everything that had just happened, correct?
I had no idea what happened.
Okay. And that you were afraid of not only because of the shots ringing out, correct?
I didn't know those were shots at the time.
Okay. You were afraid of what might happen to you in this situation, isn't that correct?
I had no idea what had happened. I didn't know what to be afraid of or what not to be afraid of.
Isn't it true, ma'am, that you were afraid that you yourself might face charges simply because you were in the car?
This was not
Sustained.
Isn't it true, ma'am, that you don't remember everything it was that Mr. Dunn told you about what happened?
That's true.
I have nothing further, Your Honor.
May she be excused? Or any other questions, Ms. Wolfson?
Just briefly, Your Honor.
Yes, ma'am.
Ms. Rauer, despite your state of shock that next day and that very night, would you have remembered whether or not the defendant told you he saw a gun?
Yes, I would.
I have no further questions, Your
May
Honor.
she be excused?
Yes, Your Honor.
Ms. Hanania, may she be excused?
Yes, Your Honor.
Thank you, ma'am. You're excused.
Thank you.
State's next witness.
Ken Lescalet?
Ken Lescalet. Sir, if you'll come all the way up to the front for me, please. And right up front, if you'll raise your right hand, the clerk will administer the oath to you.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, if you come right around this way for me. And watch your step there as you come up. And you can have a seat. And you can adjust that microphone as you need. Just be sure and speak directly into it, loud enough so everybody can hear you. Mr. Guy.
Thank you, sir. Good morning. If you'd please tell the members of the jury your name.
My name is Kenneth Lee Lescalet.
And Mr. Lescalet, where is it that you live currently?
I live in Friendship, Maryland,
And how long have you lived in that area?
for 13 years.
Are you married?
Yes.
Are you currently employed?
No.
What is it that you retired from?
I retired from the U.S. Federal Service,
In what department?
Department of Agriculture.
And when did you retire?
I retired May 31 of 2014.
And what was your position with the Department of Agriculture?
I was the director of the Protective Operations Division.
Did you carry a badge?
I did
All right. And how long were you with the Department of Agriculture?
for 18 years.
let me turn your attention to November of 2012. Were you living in Maryland at that time?
Yes,
Did you have a secondary home at that time?
yes,
Where was your secondary home?
in Satellite Beach, Florida.
And what was the purpose of your secondary home?
It was initially, we were going to make it our permanent residence, but we decided against that and we turned it into a rental property.
So how much time would you spend in your rental property in Satellite Beach?
Maybe a week per year.
And what type of residence was it?
Say again?
Was it a freestanding house, a condominium, or what?
It was a townhouse on the ocean in a gated community.
All right. And when did you first acquire that property?
In January of 2011.
All right. At some point after acquiring that property, did you meet a person named Michael Dunn?
Yes.
And approximately when did you meet Michael Dunn?
Well, it was about a year after we had moved in there.
So sometime in the early part of 2012?
Correct.
All right. You see Michael Dunn in court this morning?
Yes, he's seated at the table on the left between two females.
Let the record.
Blue suit.
I'm sorry. With the suit, he said, let the record reflect he's identified the defendant.
All right. Describe for the jury the kind of contact or the amount of contact you would have with the defendant after you moved into that rental property.
Well, there were about eight families in this complex, and the neighbors would gather sometimes on the beach or on the beach walk, and he would be pass by, we'd say hello, and it was just minimal contact.
All right. Let me turn your attention to Thanksgiving holiday weekend of 2012. Did you come to learn that the defendant was out of town that weekend?
Yes.
And how did you learn that?
They were preparing for their trip, and they asked us if we would watch their dog while they were going to Jacksonville to attend a wedding.
And when you say they, who are you referring to?
Well, it was actually Michael. He asked if we would watch his dog.
And when you say Michael, you mean Michael Dunn?
Correct.
All right. Were you and or your wife able to watch his dog?
No, we declined because we weren't certain when we were leaving.
At some point after they departed for Jacksonville, did you call the defendant by phone?
No.
Did you call him that weekend?
Yes.
When was that?
That was Saturday morning at about 8:30. My wife and I decided that we were going to depart depart Satellite Beach, and we had said, when we said we couldn't watch your dog, we said, well, maybe we could get together over the weekend. There was a place that they wanted to take us, and so because we're leaving early, I called and said, we're preparing to leave today. We were going to go to an evening mass Saturday night, and then get up early Sunday morning and depart and go back to Maryland.
What was the defendant's demeanor or mood during that phone call?
Fine. He was very upbeat, and he didn't indicate any problems or anything going on in his mind. He seemed to be perfectly fine, as I found him all the time. He was upbeat, and no indication that there was any problem.
At any point during that conversation, did the defendant say to you that he had something important to talk to you about?
Absolutely not.
Did he mention at any point during that conversation that he had anything to talk to you about?
Nothing.
And approximately how long was that phone call?
Perhaps 5 minutes. We had talked about his wedding, how he enjoyed himself, and wasn't sure what he was going to do for the rest of the weekend. So we just closed it at that. He was very upbeat, and yeah.
Did the defendant make contact with you later that morning?
Yes.
And how did that come about?
My wife and I were out preparing to get ready to go. We had gone on the beach for a minute. We were walking back, and I saw him there, and he was walking his dog, and we waved to him, and he waved back. That was the extent of that.
Did he then come over to your residence?
Probably 10 minutes later, my wife and I were in our house. He walked up to our sliding door, which was on the patio, and he knocked and then he opened the door, and he sort of stepped in to the house.
Did he call you before he came over?
No.
And eventually that morning, was he arrested near your residence?
Yes.
Thank you, sir. That's all I have.
Mr. Carlisle?
You second, Your Honor.
Yes.
Good morning, sir.
Good morning, sir.
You testified that you had minimal contact with Mr. Dunn. Is that correct?
Yes.
But you had actually gone out and had drinks with Mr. Dunn and Ms. Rao?
The minimal contact I was talking about was during that first year or so. This week of the incident, we had gone out to dinner at least twice.
And that's with Mr. Dunn and Ms. Rao?
Correct.
Okay. So he was a social acquaintance, would that be?
Acquaintance, that's
Okay.
correct.
Now, you testified that when you spoke to Mr. Dunn on the phone that his demeanor seemed fine,
He was fine.
but you would agree that you could not see his facial expressions
Correct.
and that sometimes the tone of voice can be lost throughout the phone?
I object to common speculation.
Sustained.
Now, Mr. Dunn, I believe you testified, came over to your sliding door, and would you agree that he was very distraught?
Yes.
And you had never seen him like that before?
Correct.
And he told you about what happened?
I'm going to object this to proper hearsay.
Well, without getting into specifics, I'll let that question go.
Did he discuss why he was coming over to your house?
He just,
No, sir. Did he? I don't want you to say anything about specifics. So rephrase the question, Mr. Carlisle.
When he came over, after interacting with him, did you know the purpose for his visit?
oh, like I said, he knocked twice. He opened the door, and he saw me there, and he stepped in, and he said that...
No, sir. You can't say what he said.
Okay.
After interacting, did you know the purpose for why he came over to your house that morning?
I knew that he was in trouble with the law.
And at his request, did you call 911?
No, I said to him, I said, you need to talk with the police. And my concern...
Well, let me stop you right there. It was your decision to call 911?
Yes, it was.
And did, as far as you could tell, did he see you dialing the phone?
Oh, yes.
Did he try to leave?
No.
And did he get a phone call while you were dialing 911?
Yes, it all happened very quickly. I was on the phone with 911, and I was trying to explain to them what I had gathered from Mr. Dunn. And my concern was to make sure that, I had no authority.
I just object to being non-responsive.
Sustained.
When you called 911, Mr. Dunn didn't try to leave, correct?
No.
And after Mr. Dunn received the phone call, he went outside?
Correct.
And you witnessed him being taken into custody?
Yes.
Did he resist at any point?
No.
He didn't try to run?
No.
May I have a moment, Your Honor?
Yes, sir.
Nothing further.
Mr. Guy, may he be excused?
He may.
Thank you, sir. You're excused.
Thank you, sir.
All right, ladies and gentlemen, we're going to take a lunch break. And so again, please do not discuss the case among yourselves. We're not to the finish line yet. Don't let anybody discuss the case with you or approach you. We'll watch your notes. We're going to break and resume at 12:45 today. So it's a 45-minute lunch today. So see you back at 12:45. Ms. Abel, jury instructions.
Yes, sir.
Let's go over those now. Again, the first page is my signature page. Second is thanking the jury. Third is statement of the charge, which has been made singular. The next page is introduction to homicide. Let me ask a question. Under justifiable homicide, do you want to leave in there or to commit a felony in any dwelling house in which the defendant was at the time of the killing?
Yes, sir.
You want to leave that in?
Yes, sir.
Okay. So that's basically the standard instruction. Any objection to that from the defense?
No, sir.
From the state? Moving on to the first-degree murder instruction. Again, standard instruction. Any objection from the defense?
No, Your Honor.
State. Moving on to the next, which would be lesser included offenses, which includes second-degree murder and manslaughter. Any objection from the defense?
No, sir.
State.
There's no objection.
Moving on to the actual instruction for second-degree murder, it's the standard instruction. Any objection from the defense?
No, sir.
State.
No objection.
Moving on to the instruction for manslaughter. Again, it has that portion under the justifiable homicide part about committing a felony in any dwelling house. You want to leave that in, Ms. Abel?
Yes, sir.
Okay, so it would be the full standard instruction. Any objection from the defense?
No, sir.
State.
On which one is that on this?
Manslaughter.
No, sir, no objection.
Next is justifiable use of deadly force. It appears to have the redactions that we had in there, basically simplifying it so I don't have to continually define assault and battery. So it looks to be in order to me. Any objection from the defense?
Your Honor, I would request in the very first paragraph where it talks about we added and the lesser included offenses, I would request the court that it reads and the lesser included offenses of second-degree murder and manslaughter.
All right. Any objection to doing that, Ms. Corey?
Well, I don't want to say of second degree, because it makes it look like it's lesser included of second degree and manslaughter, just lesser included offenses, comma, second degree murder and manslaughter, right? She used the word of, but I don't think we should put that in. If you read something.
I wasn't an English major, so I don't know.
Let me-
Sounded okay to me,
And the
but
lesser included offenses, comma, second degree murder.
I think that makes it more confusing if you put a comma.
I think you can put and the lesser included offenses of second degree murder and manslaughter. It makes it look like there are lesser included of second degree and manslaughter. That's why I'm saying the word of does.
I'm missing it. I think there are lesser included offenses of second-degree murder and manslaughter. We got a lot of English majors probably in the back that could tell you. I got no clue.
Maybe I'm reading too much into it.
Probably.
Okay, I sent you that. Okay. I'm saying the word of would be specific to lesser included belonging to second degree murder and manslaughter, whereas all we want to say is first degree murder and its lesser included.
How about we say lesser included offenses, which I previously indicated to you are second-degree murder and manslaughter?
That would be acceptable.
Hold on. Previously if the death is ordained. Right. Okay.
Okay?
Yes, sir.
Other than that, any objection to justifiable use of deadly force?
Yes, sir, from the state there is. And we had to wait until we heard the defense testimony before I brought this up. Do you want to hear it from them before me, or you want me to go ahead?
They don't have any more objections to it.
My objection again, Judge, like last time, is I don't believe the defense has established their ability to request 78202, which is justifiable homicide, because he did not testify that Jordan Davis did anything to him within his vehicle, which is what's required for justifiable homicide. As I mentioned, I believe, at the last charge conference months ago, that justifiable homicide is a statute. When you read trespassing your own dwelling. And as I believe the court pointed out, that would extend to your vehicle. However, in this case, Mr. Dunn's testimony, and I waited to see what he's going to say today, is limited to him being in his car where he has a right to be in a public parking lot, and Jordan Davis and those three young men being in their car where they have a right to be. There is no crime that he's claiming was committed in his vehicle, as is required by justifiable homicide. So we believe that what that leaves them with is a justifiable use of deadly force, which applies to people who are on equal ground, so to speak. And again, I think last time...
Well, what part are you talking about deleting?
The first section is justifiable homicide, 78202. So it would be the very first optional section which starts at...
I don't have that instruction in front of me.
Yes, sir.
I don't see the options. I want to know what you want to delete.
Okay, on page 13,
Yes, ma'am.
third paragraph, well, deadly force isn't really a paragraph, but right under that where it starts, the use of deadly force,
Yes.
those three options, and then the definitions, we would have to move those all the way to page 14, where it starts in the justifiable use of deadly force, which is the second paragraph. And we have to move the definitions. One other thing about the definitions, Judge, I believe that we're instructing the jury on too many things. Jordan Davis could have been doing this. I don't know why assault and battery are in there. If Jordan Davis was attempting to murder him, then that covers everything.
Well, you're compounding it now, but
I am. You want me to wait for this?
no, I want you to clarify for me. So
Yes, sir.
after deadly force, this is on page 13.
Yes, sir.
It starts, the use of deadly force is justifiable if Michael Dunn reasonably believes, and it goes on. So you're saying from there all the way over to the top of page 14, you want excluded.
Yes, sir. The state's position is...
I know the position. I'm asking you so I get it clear in my mind what you want excluded.
Yes, sir.
So you want it to read, deadly force means force likely to cause death or great bodily harm, and then skip all the way over and say, Michael Dunn is justified in using deadly force if he reasonably believes that such force is necessary to prevent, and then those two things.
Yes, sir.
Okay. Now, that includes aggravated assault, aggravated battery, attempted murder, or murder. You mentioned why is assault and battery in there. I agree to some extent. However, it's in there because assault is part of the definition of aggravated assault. So that's why it's there. I was looking at it and I kind of agree. It really ought to, in my mind, and I'm back over onto page 13 now, which is part of what she wants removed but would have to be added back in. An assault is an intentional unlawful threat, et cetera, et cetera. And then at the end it says an aggravated assault is an assault with a deadly weapon. In my mind, it almost ought to start off with an aggravated assault is an assault with a deadly weapon without intent to kill or with an intent to commit a felony. And then perhaps underneath that you would put the definition of assault is...
Or Judge, if you don't mind me offering a suggestion, maybe just craft, since it's not something the jury has to find every element of, maybe just craft a combined definition of aggravated assault, aggravated battery. Again, those are two crimes that are included in murder. His testimony was clear, he knew Jordan Davis was trying to kill him. Not assaulting, not battering, but killing. So I think if you say that, it would cover it. But in the abundance of caution, the court thinks we should read all four of them. I would suggest a combined definition for aggravated assault, aggravated battery to make it easier to read, or easier to understand.
I tend to agree with you, but, and if the defense is okay with it, then we can craft something. The only thing, quite frankly, I worry about is if you deviate from standard jury instructions, you're running the risk of getting reversed. Because quite frankly, you can read a standard jury instruction that was agreed to by all parties, and we all know of cases where the judge read the exact standard jury instruction that was promulgated by the Supreme Court of Florida, and either a district court of appeal or the Supreme Court of Florida reversed a defendant's conviction because they later, after the fact, decided that the instruction wasn't very good, even though the judge read exactly what had been promulgated.
Yes, sir.
So,
Just leave that.
I agree with you. I think it would be nice to have, I don't know, somebody on a committee that helps to make these things read a little bit more in a way that is understandable by a lay person. Because it's many times very difficult even for lawyers to read these things and absorb it all and get what it means. But I'll do whatever y'all want.
Your Honor, I'm requesting that we read the standard jury instruction.
Okay.
And
So that part's out. Now, let's go back to their argument that the first part of justifiable use of deadly force, really it adds number 3. The only difference between that and the second one is, well, it's a little bit different language. It talks about imminent death in the second one, imminent commission of. In the first one, another's attempt to murder, another's attempt to commit ag assault, ag battery, etc.
May I clarify something, Your Honor?
Yeah.
It's my understanding that is the state saying that what they want to do is take out the bulk of the justifiable use of deadly force instruction?
Yes.
Okay.
Because they're saying it applies to 2 different things. They're saying the first part of it applies to Mr. Dunn being in a vehicle, which he was, and that the attempt to commit the aggravated assault, aggravated battery, or attempted murder was towards him while he was in the vehicle.
No, sir, that it occurred in his vehicle. Justifiable homicide protects the person when they are within their, and the perpetrator attacks them within their home or vehicle. That's the difference between justifiable homicide and justifiable use of deadly force.
Okay, well, that request is denied because obviously the case law has expanded that. You don't literally have to be inside your home. Quite frankly, you can be in your garage, which some people might consider to be in your home. You can be in your front yard. And so I believe that if you are in a vehicle and somebody is approaching the vehicle in an attempt to kill you, that this would apply.
Yes, sir.
So it stays in.
Yes, sir.
So then we're reading it as is.
That's correct, sir.
And over the
With-
state's
with the ex-
objection, we'll read it as is.
With the exception of adding the lesser included offenses in paragraph 1 that we previously discussed.
Correct. Plea of not guilty, reasonable doubt.
No objection, Your Honor.
Date of crime.
No objection.
Venue.
No objection.
Weighing the evidence, we've got 1 through 8, which we discussed yesterday, so that looks correct.
Yes, sir.
State good with everything I've said so far.
Yes, sir.
Moving on to the second page of weighing the evidence, the defendant has become a witness, so that needs to be not bolded. And then at the bottom of the page, the business about the, whatever that is, just take it out.
Yes, sir.
Then we will take out, well, so that's that.
If we corrected, I believe we need to see if the defense is wanting to add back any of the optional weighing the evidence. We added in 6, 7, and 8 are 3 of the 5.
We handled that yesterday, Ms. Corey.
We just sort of now that I'm just asking in abundance of caution now that they've gone more
Well,
case.
Ms. Corey, I just asked them if they had an objection. They said no.
Okay,
Am I right, Ms. Abel?
Correct.
thank you.
Defendant's statements, I guess we're going to wait on that.
Yes,
Because
sir.
at this point, we do not have any defendant's Mirandized statements that have been entered into evidence.
Yes, sir.
Rules for deliberation, that's standard. Cautionary instruction, any objection on those?
No, sir.
Notes,
No objection.
verdict.
No objection.
Submitting the case,
No objection.
and this one doesn't have a copy of the verdict forms with it, so they're the same, so I don't see any problem. So if I'm correct, we really only have to make one change to the justifiable use of deadly force instruction, and we have to determine whether we get any defendant's Mirandized statements. Other than that, the jury instructions are in order.
I'm just thinking off the top of my head, didn't he say on his direct that he was read Miranda, and then they elicited from him some statements? So, I mean, I guess at this point, if they asked for it, we wouldn't object. I guess it's up to them, but I think there was some testimony that he made statements after Miranda.
There was. I'm guessing they probably don't care because they're not arguing that he didn't freely and voluntarily give these statements. And you know, that just tells the jury you need to analyze these things, and if they weren't freely and voluntarily made, then disregard his statements. They don't want them disregarded, so I doubt they're going to want the instruction, but you never know. And we don't know what additional rebuttal you've got unless you've made that decision.
Not just yes or no.
So we'll see.
Then we'll wait, Your Honor.
We'll table that. Other than that, and other than adding that one thing into justifiable use of deadly force, all instructions are agreeable from the defense?
Yes, sir.
From the state?
Yes, sir.
Okay. So if you'll fix that, and I want I'm going to want a copy. I need an original. I want a copy for myself. These are hard copies. And I want 12 copies for the jury.
Or 15.
12. We're only going to have 12 people because they're not going, I don't give it to them while I'm reading them. I want them to listen. When they go to the jury room, they'll each have a copy. So we only need 12.
Understood.
I don't want them, I'll tell them, I give them a copy to look at when they go back. I want them to listen rather than try and read along because I want them to.
Well, just to make sure, I need to say during instructions for, let me say this and send it to Miss Abel, let her check to make sure everything I did conforms with what you just instructed me to do. And then I'll take out the watermark, and you want us to make a copy, have it, one for you, an original, that you'll sign, another one for you.
That I'll read from
that you
because sometimes I mark them up a little bit.
So if she agrees with me, I'll have somebody deliver those two to you.
You can just bring them to the courtroom.
Bring them to the courtroom, and
Yeah.
then have the 12 copies ready for the jury.
Right. You can give me, you'll end up giving me an original and 13.
Yes, sir, but until we've made our decision on.
Right.
We've got to wait, okay, I've got it, and I'm gonna go ahead and forward these to my mother.
Well, I say that, I mean, the only thing, because defendant's statements is, well, the page numbers would be different,
Yes,
so,
sir.
okay.
And the verdict forms are good. We haven't
I guess so.
Looked at them in court, I just want to make sure.
You-
So we looked at it 3 days ago.
And the defense is fine with them?
Yes, sir.
Okay. All right. Well, then, we're going to resume at 1:15. You're going to, now let me tell you, if you don't have another rebuttal witness, we're starting closing arguments. If you do, we'll do that, and depending on how long that is, we're going to go to closing arguments. My feeling is we're going to do closing arguments today, and if that means we're going to stay down here a little bit later, we may, and then that way we'll have a full day in, and then they'll go to the hotel tonight and they'll come back in the morning. I'll read them the jury instructions and they can begin their deliberations tomorrow morning. That's what I'm thinking. So, see y'all in about 25 minutes.